There are 15 statutory conditions in Chapter 3. We'll start with Chapter 1. Number 1. Chapter 3, Part B. Statutory Condition 1. Misrepresentation. A client or insured falsely applying for insurance. Contract is void upon the knowledge of the insurer. 3 forms of misrepresentation. 1. Accidental or deliberate provided by the insured is inadequate information will hurt the insurer because of the disadvantage. If the insurer knew about it, would cause a decline in the risk altogether or charged a higher premium for accepting it. Previous claims, cancellation, refusal of insurance, existing property protection system is not there, it will be void. Deliberately omitted or disclosed the material fact to obtain coverage, means done it on purpose to obtain lower insurance coverage, will also void the coverage. And these are 3 forms of misrepresentation: inadequate or charging a higher premium for accepting it, or deliberately omitting and disclosing the material facts. Note: effect of the misrepresentation on the contract of the insurance. The insurer will have the right to void the contract which has misrepresentation. So make sure the brokerage will follow this transaction. Statutory condition 2. Property of others. Insurer is not liable for loss or damage to property owned by any other person after proving that it was linked to misrepresentation. So no third party on the contract. The insurer itself will not pay. Statutory condition 3. Change of interest. Insurer is liable only for the parties to the contract for the loss or damage occurring after the authorized assignment under the Bankruptcy Act, Canada, or changed of title by succession, operated by law, or change of title by death. The property will transfer to the new owner on policy, such as if the husband was on there, the wife will be now in control. Statutory condition 4. Material change. A notification is required as soon as possible for the insurer. There will be additional premium upon notification, and if not premium not paid, unearned portion will be returned. So the condition will be cancelled. If there is a material change, you have to be written a notice within 15 days by registered mail or 5 days by hand delivery. Onus on insured to notify of material change. Onus means the person on the policy has to inform, return the unearned premium and cancel the policy, or retain the risk and advise the insured in writing of the additional premium required. So if there is any material change, the premiums will go higher. So if you want to cancel it, it will be cancelled immediately. Stationery file. Which is termination. Currently we were talking about. A contract will only be terminated upon the request in writing and signed by all persons stated on the policy must be provided in the insurer. 5 days by the hand delivery or 15 days by registered mail. Contract is cancelled by the insurer. Insurer shall refund the excess premium at pro rata and shall accompany the notice of adjustment. Contract is terminated by the insured. The excess premium is calculated on short rate after the process of administrative cost. The refund may be money, postal or express, money order or check payable at par. 15 days mentioned in clause of subcondition for post office to which the refund is addressed with a registered letter. Note: the termination can occur automatically or in the duration of completion date. or by the insured itself. Statutory Condition 6. Requirements after loss. Observation or observing the requirements of conditions following Condition 9, salvage, 10, entry, control, amendment, and 11 is appraisal. So when a loss occurs, you have to follow 9, 10, 11. Or the first thing you have to do is forthwith notice of loss in writing to ensure. Proof of loss verified by a statutory declaration. That means you have to take the declaration page showing this is the person, this is the property, location, date, time, the amount of the insurance. Provide a complete inventory of the loss or damage showing detailed quantities, cost, actual cash value, and particulars of amount of loss claimed. Inform of when and how the loss has occurred. Was it fire? Stating the loss or occurrence of act of neglects. Providing declaration page with names and coverage. Any liens, encumbrance, or other charges on the property must be informed. Showing changes in title, use, occupation, location, possession, or exposure of the property since the act is insured. Showing that the property was insured at the time of the loss. So note, in business, follow conditions 12 when loss is payable, 13 replacement. Same applies but with additional information on the business practice, books and records verified by statutory declaration and any other contracts with it. So this matters to property and business. Statutory condition number 7, fraud. Here you should know the difference between fraud and negligence. It's very important. Fraud is deliberately attempted to deceive with a view to securing profit, but an honest mistake is not considered a fraud. So accidental is not considered fraud. Example, an insured had a reasonable chance to protect property from loss but failed to do any such thing. This does not affect the claim. It does affect the claim. You will always want to protect your property from fire or any additional loss. Statutory condition 8. Who may give notice and proof? An agent, a person from named insured on the contract, a lawyer, friend, or relative. Statutory condition 9. Salvage. This will be on the test. A condition is designed to avoid the economic waste. The safety of the insured is more important to the insurer than the property, which might be saved. Salvage means take responsible steps to prevent further damage to the property. The insurer will contribute pro rata towards any reasonable expenses incurred while taking the steps to protect such subparagraph 1 of the condition. So this will be on the test. Statutory condition 10, entry, control, abandonment. Entry is the insurer has an immediate right of access and entry by accrediting agent to survey and examine and to make the estimate of the loss or damages to the property and after an appraisal. The control is the insurer is not entitled to control but has to take the permission from the insured to enter his property. Abandonment, the property cannot be abandoned without the consent of the insurer. Statutory condition 11, appraisal. An appraisal is hired in case of disagreement as to the value of the property insured. He or she determines the recovery amount under the contract and under the Insurance Act. The majority of the claims are settled with little or no disagreement. This condition allows either party to ask that disputes involving violation be settled by appraisal, the details of which are provided in the Insurance Act. Statutory condition 12. When losses is payable. 60 days after completion of the proof of loss, unless the contract provides for a shorter period. So remember that 60 days the loss is payable. Statutory condition 13, repair and replacement. A written notice is given of its intention by the insurer within 30 days after the proof of loss. The repair and replacement shall commence on the property within 45 days. Statutory condition 14, action. An action in court for any claim shall be commenced within 1 year. Statutory condition 15, notice. A written notice shall be delivered by registered mail in 15 days or 5 days for hand delivery, or notice or mail the notice to chief agency or head office. Things you like to remember, or we'll make it separately. End of chapter 3, part B. Thank you. We'll continue on some things that you need to remember for the test. Look at part C.